Thank you. Please be seated. Good morning and welcome to the Idaho Supreme Court. Today is May 14, 2025. The first matter set for hearing this morning is Smith v. Steven Hippler, Administrative District Judge. Appeal number 51412. Vernon K. Smith is present, representing himself, with Judge Hippler being represented by, how do I say your first name?
Gator.
Gator. Okay, I didn't want to mispronounce it. Gator Wren and Michael Azarian appearing only. Per our order, Respondent Elsesser is not participating in this appeal. Any preliminary matters from counsel or from you, Mr. Smith?
I believe not, Your Honor.
No, Your Honor.
Very well, Mr. Smith. You may proceed.
Thank you, Your Honor. Good morning, and may it please the Court. The appeal before you today concerns the entry of a pre-filing order issued by an administrative judge upon the referral of a judge supervising an intestate probate estate. That referral was made upon the basis of the motion of the personal representative that had been submitted to that probate judge, following the filing of a petition for his removal and the denial of that petition, all of which was taking place in an estate that had been ongoing for 9 years, which raises the question, what is this estate? This estate was initially created in 2014. It began with the invalidation of a holographic will. It then went to the creation of an intestate estate in which notice to creditors was submitted and published, and there were no creditor claims. Zero liability in an intestate estate. To that, we have Magistrate Copsey finding it to be an assetless estate, so she seizes assets pursuant to a Rule 70B instrument, receiving assets from VHS properties, all of which were debt-free. No liability, no judgments, no unpaid real property taxes, no mortgages, no deeds of trust. Following that, with no creditor claims and assets that are debt-free, we have properly filed an official inventory and a certified appraisal report. That's filed on August 7, 2017, setting forth under oath in that official inventory and certified appraisal that the value of those assets at the time of death, September 11, 2013, had a value, an appraised value, certified value of $5,836,452. What then do you do in an estate that has no creditor claims for a personal representative to resolve, that has debt-free assets, and you just had your appraised, established inventory? What's left in an estate to do is to file an estate tax return, virtually no estate tax liability given the allowance of the exemption. And then what do? You have a distribution under the Uniform Probate Code. Now that's the responsibility of a personal representative. Now that's how we begin what we're dealing with. Now we go year after year after year after year as these assets increase dramatically in value because of inflation, because of the economy, because we had just come out of that recession of 2008, and in 2013 it was still there. Now these property assets are mushrooming in value. So what do we find? We find there's churning of fees. Now you might not like that word, and I certainly didn't like what I was saying, but churning of fees, lawsuits, claims, motions, arguments. What do we have? We lose $20 million in value. They begin liquidating. Why are we liquidating assets in an estate that had no claims and no debt? It's to fund administrative fees and attorney fees. $20 million dissipated and squandered, and by now, $5 million in attorney fees. Now, I submit to you, Your Honors, something is wrong. Something is amiss in the state of Idaho if this is allowed to take place. So what happens after 9 years and after directives becomes rather interesting. There's the statutes. There's the statutes 15.3.501, 15.3.611, 15.3.712. They mean something. The legislature created them to mean something and to be used effectively. Now, what's interesting about those statutes, those statutory rights, those rights to access the court for relief, is this court, in a case that emanated out of this probate, called Elsasser, that's the personal representative, Elsasser versus Gibson. What this court stated in 2021, the relationship of the personal representative to the estate is that of a trustee. Amen, brother. That's a fact. Interested persons who are apprehensive of possible misuse of power by a personal representative may secure themselves. Now, this is the Idaho Supreme Court stating this. May secure themselves by use of the devices implicit in the several sections of Part 1 and 3 of this article. See specifically sections 15.3.501. That's the directives. That's what I used. 15.3.605, that deals with the issuance of bonds, which, by the way, bonds were requested and bonds were obtained. Who pays the premium? This estate paid the premium, not the personal representative. Many, many, many tens of thousands of dollars paid. 15.3.607 and ultimately 15.3.611. What is 15.3.611? The petition for the removal. And what is 15.3.501? That's a wonderful statute that says interested persons are vested with the authority to make demands, to make the directions to the personal representative. The court can do it, and the interested person can do it. So that's what was done. Finally, in February 21, 2023, after directive after directive after directive to mitigate these damages, to stop these losses, to stop liquidating assets that were free and clear, to stop the waste when there's no creditor claims. What are we doing? And they ignore it. Those particular directives were attached to the petition for the removal ultimately filed in February 21, 2023. Pretty detailed, pretty complete. Yes, the intent was to remove the personal representative. Absolutely. 9 years. That was the intent. And knowing that Judge Copsey, having for 9 years observed what I deem to be the lack of impartiality, having had 2 prior attorney firms representing my interest, in their own opinion, for their combined 100+ years of law practice, determined they were wasting their time and their effort and my financial resources representing my interest in a probate with a judge who they observed to have a complete lack of impartiality. What was she doing? Well, in 2021, before Mr. Clark, in a hearing, in an offset proceeding, chose to misrepresent to the court again. And that's been set forth in briefs. What was that misrepresentation? It was significant. And they should have been sanctioned for, but no, they weren't sanctioned. So realizing that Judge Copsey would continue to shield the very personal representative that I sought to remove because of what was going on with the dissipation and squandering of these proceeds, moved to disqualify her. Now, yes, that was the third time the motion to disqualify had been filed. The first time by Rory Jones in 2019 when he had had enough of what he had seen. The second time was Mr. Clark in 2021 when he had had enough of what he had seen. And now the third time filed by me personally in support of the petition for removal.
Mr. Smith, wasn't that motion made as in
Your Honor, you got to speak up so I can hear you.
wasn't the motion made without cause under Rule 40A, which violated our rule and order that said it wasn't even in effect at that time?
The motion was filed within 7 days.
Is that a yes or a no? Was it filed as a motion to disqualify the judge under Rule 40A without cause?
There was cause because there was
That's not an answer. Was it filed under Rule 40A as Judge Hippler found and as Judge Copsey ruled that wasn't even in existence at the time you filed the motion?
Let me try to answer the question. The motion was filed to disqualify, to recuse Judge Copsey with cause and without cause. So I had to file it within 7 days without cause, preparing both the declaration and the memorandum. Judge Copsey was on vacation somewhere down on the Riviera in Mexico. We knew we had plenty of time to submit the declaration and the memorandum, and they were prepared and they were submitted. And there was objections filed, and there was a hearing requested, and the judge ruled we don't need a hearing. She vacated the oral argument. That she came out with her ruling on March 31 of 2023 denying the motion. So to answer your question, it was supported adequately. The motion had to be filed immediately under the rule for without cause. So there was the need to disqualify Judge Copsey because she could not sit and make a determination impartially. So now we have the denial of the petition for removal. And immediately following that denial, we have the motion from the personal representative for a declaration of a vexatious litigant. We then had the referral from Judge Copsey to the administrative judge, Judge Hippler. And Judge Hippler entered the particular pre-filing order. Now the question, I've raised a number of issues, and how to address those issues, how does the Supreme Court want to react or address those issues? Part of my argument has been that the activity taken by the appellant in filing the petition and in the directives, those were statutory rights. Those were property rights that the legislature of Idaho has granted to an interested person to pursue and to use in the only venue that's available, and that is the court system.
And where do any of those statutes allow the filing of frivolous litigation? Frivolous litigation. I don't see anything in those statutes that allows the filing of motions that are unsupported by fact or law.
Well, now, the petition for removal was supported, it's a very lengthy petition, and it had very detailed facts. It was furthermore supported by a declaration as to what the claims were. It was furthermore supported by a memorandum, and it was of authority, and it was furthermore supported by the list of witnesses. This was all submitted, and it's quite extensive. Nothing frivolous about what was presented. Keep in mind, Your Honor, we're looking at an estate, had no creditor claims, debt-free assets, and 9 years.
Counsel, Judge Copsey and Judge Hippler both found, despite everything you filed in support of that motion, that it was frivolous. And if I recall, in particular, the decision was based on the fact that the personal representative doesn't owe the beneficiaries a fiduciary duty, which was the crux of your motion. And I haven't seen anywhere in your materials that you've sought to rebut that, or you have otherwise appealed it and prevailed.
There's only certain things you may appeal in a probate. They're identified in 17201. The only way I could appeal certain things is that which qualified under that statute. The first thing I had that qualified under that statute, 17201, was a denial of the petition for removal. That began the appeal. Now,
And so where have you rebutted the conclusion that your motion, which was premised on an allegation that the personal representative owed you fiduciary duties, and the court held that is not the law, and that the statute did not support the bases you asserted for removal? Where have you rebutted that?
I believe the facts of a 9-year probate.
No, before this court. This action is about Judge Hippler's, the administrative district judge's pre-filing order. That is what we are here to talk about today. It is premised on a conclusion and a finding that you have filed multiple pro se, frivolous motions and notices of appeal that have failed to comply with the rules. So when we're talking about your motion to remove the personal representative, which is one of the 5 bases on which the ADJ found you had filed successive frivolous motions, that determination that it was frivolous was premised on the conclusion that the statute you asserted did not in fact prohibit what you claimed it did, and that the fiduciary did not in fact owe you, or that the personal representative did not in fact owe you fiduciary responsibilities or duties. So when we are looking at that one piece of the finding in the pre-filing order, what have you asserted before this court with specificity, with citations to law and citations to the record to establish that was incorrect?
What I have submitted to this court is a position that Idaho does not have an established procedure or an established law in terms of a standard to be applied to an individual exercising a statutory right. Now, you raised the statement just a moment ago, and I'm going to respond to it. You said that I have made repeatedly filing motions. Now, you just said that. When you look at the record of this now 10-year-old probate, you're going to have a difficult time finding where I have filed repeated frivolous motions.
And sir, I am focusing my questions on the pre-filing order, the filings that are the subject of the ADJ's pre-filing order. And you were put on notice of what those filings were, and I don't see anywhere in the record before this court where you have asserted any of those conclusions are incorrect. And I return to your statutory argument. Nothing in those statutes provides you the right to make repeated filings that are unsupported by fact or law. So I'm not seeing where your statutory rights to file anything have been impaired. Instead, the pre-filing order requires you to submit evidence to the ADJ that you are filing something that is supported by fact and law. And if you make that finding, you will be permitted to file it. So I'm struggling to see where there's any impairment of your statutory rights to file motions that are supported by fact and law.
Trying to follow through what you're saying, when the first pre-filing proposed order came out, Judge Hippler relied extensively, if not entirely, upon the belief that he had not been provided a copy of the declaration or the memorandum.
That is not what he said. His notice order said you filed it a month after you filed the third motion to disqualify the court.
And I've tried to explain to you why the motion for disqualification had to be filed within 7 days, because it was a two-part motion. It was both with cause and it was without cause. And it had to be.
And I understand that, sir, but the argument you raise repeatedly in your briefing is that the ADJ erred because he erroneously concluded you didn't file a supporting declaration or memorandum. And I'm saying to you, that's not what his order says. What his order says is you filed the third motion to disqualify, and then a month later, you filed the supporting memorandum and supporting declaration. So I'm not seeing anywhere in the record where he made a decision based on a belief that you never filed a declaration or a memorandum.
Well, that was certainly my belief from what I reviewed in his proposed pre-filing order, and that's why I submitted to him what he had apparently not, in my opinion, received. And I gave him a copy of both the declaration and a copy of the memorandum in support of the removal. So there was justification, there was cause. I'm the third person who finally had enough of the lack of impartiality and filed the motion, believing Judge Copsey could not sit and preside over the petition for removal of the personal representative and be impartial, because she had already shielded him from sanctions that should have been given back in 2021. It was, to me, obvious. Now, in terms of the concept of what I've been raising as an issue, and that is, I have a statutory right to proceed. The argument they're trying to make for the vexatious litigation is that they realize that I'm next going to go to 15.3.712. I'm going to be filing an action for recovery of all these damages. And they know that. They don't want to be exposed to the accountability. That's why if I did all these nasty things you're referring to, which I was trying to tell you I haven't filed motions at all that have been frivolous. But that being said, if I'm so nasty in this probate, why wait for 9 years? It only appears when I filed the petition for removal, because they realize they got a problem. You 5 Supreme Court justices have to realize there has to be a problem in this probate. A probate that goes on for now 10 years, no distribution of 1 penny to anybody, that had no debts and no creditor claims. Now, you cannot sit there and say this probate is an excellent, stellar example of how a probate is supposed to be run. You can't. You simply can't. So part of the concern that I have raised with the issues I presented to you is I have a statutory right to do what I'm doing under 501 directives, under 5611 for removal, and under ultimately 712. I have that right. Now, what's interesting is this court less than 6 months ago, you came up with a decision in the Greenfield case, Greenfield versus Meyer. At that time, Justice Meyer was the administrative judge in the 1st District, currently sitting on the Idaho Supreme Court. In that particular case, this court said, initially, we note that while this court has been presented with the issue in the past, now what issue is that? It's a property right issue. You have a property right to have access to the court without first getting permission from the court system to use access to the court. So you said, initially we note that while this court has been presented with the issue in the past, we have not definitively determined whether a person has a protected liberty or property interest in filing pro se litigation without prior permission from a court. You then refer to the Telford case, and you then refer to the In re Cook case, which you somewhat address that. Then you go on to say in the Greenfield case, as in these previous cases, we need not decide that issue in the present matter. Even assuming, now this is interesting, you say even assuming that Greenfield has a protected liberty or property interest in filing pro se litigation without permission of a court, we consider that she was afforded adequate due process of law. Now, what's interesting about that Greenfield case is that's touching upon the very issue that I'm raising. It's a subspecies of the issue that I'm raising. I'm raising that I have a statutory right, and I think, in fact, the Constitution says I have a property right. Now, you've gotten right up to the threshold of the issue, but you all 5 walked away from it by saying, we conclude she was afforded adequate due process of law. Now, I submit to you, those are 2 very distinct issues. Due process of law, that's a right to notice. That's a right to appear and defend, to appear and present whatever needs to be presented. Due process is entirely different from whether or not you have a property right vested through the Constitution to have access to the court. So now what you have, I believe, is this case I'm presenting to you. I say this case of mine, whether you like it or not, this case of mine presents to you what you have been dodging in the Telford case, dodging in the Root case, and once again stayed away from in the Greenfield case. And that is, you have to decide, is there a property right to which a person, a pro se person. Now, why do we pick a pro se as opposed to an attorney? We're saying a pro se person to have access, unfettered access to the courts without first requesting permission from the court. The only avenue, the only revenue you have, the only way you can get there, the only venue you can get there. So I think this case, as a subspecies of what I'm arguing, is before you. And I think you have to take it and tackle it.
Was it raised below, before Judge Hippler, your constitutional claims that you're now raising in oral argument? You're certainly aware of the preservation requirements of this court that require you to have raised it before the district judge, give him a chance to weigh in on this.
Well, if you
so
want to
before we're told by you that we have to address it, you have to have preserved it, and I'm not sure you have.
Well, I think if you read my brief again and again and again, I think you'll find out, as superfluous as I might have been in trying to express what I was trying to tell this court, I think you will find I've raised it as a constitutional issue. I believe I've said the Constitution...
I'm not talking your brief to this court. I'm talking your brief to the district court. Preservation has to have been acquired and achieved there, not in your brief to this court, creating a new issue that was never raised below.
To give the direct answer to your question, constitutional issues can be raised at any time for the first time on appeal. And so it's there. I've raised it in the brief. It's before you. My argument is that I have a statutory right that cannot be abridged. To that, I believe we have a constitutional property
Mr. Smith,
right.
you're out of time. Your time is up, sir.
Oh, thank you, Your Honor. And thank you.
Mr. Wren, when you're ready.
Mr. Chief Justice, and may it please the court, to curb the effect of vexatious litigation, this court implemented Idaho Court Administrative Rule 59, which allows administrative court district judges to designate individuals as vexatious litigants. Consistent with constitutional demands, vexatious litigants are not prohibited from entering the courthouse doors. Vexatious litigants represented by counsel are free to litigate their cases in ordinary course. Pro se vexatious litigants are free to file new civil claims once they have been given leave of court. Today's case is not difficult. Mr. Smith submitted a series of meritless filings delaying probate proceedings that are now ongoing for more than a decade. As a result of that delay, the personal representative filed for a motion to declare Mr. Smith a vexatious litigant. That motion was referred to Judge Hippler for determination. After a thorough and independent review of the record, Judge Hippler concluded that the filings submitted by Mr. Smith were meritless because they lacked any cogent argument. He then declared Mr. Smith a vexatious litigant, and this court should affirm. Mr. Smith has a long history of filing meritless claims before district courts in Idaho and has been admonished by this court and several other district courts. But this court does not need to undertake a full review of yet another record involving Mr. Smith. It may affirm Judge Hippler's decision based on procedural bars that apply here today. This court has repeatedly held that where an appellant fails to adequately brief arguments, those arguments are forfeited. That is exactly what has happened here today. In Mr. Smith's brief, he has failed to provide any cogent arguments with citation to legal authority or record citations. An additional procedural bar applies to Mr. Smith's due process claim. As the Chief indicated, that issue was not raised below and is therefore not preserved for appeal. However, inasmuch as this court wishes to address the merits of this case, an abuse of discretion standard should be applied to Judge Hippler's decision. In Judge Hippler's proposed findings, Judge Hippler did a thorough analysis of the record and found that Mr. Hippler's filings contained no cogent legal arguments, no citations to binding case law. Nothing in the record before this court, nothing mentioned by Mr. Smith in his briefs, and nothing mentioned by Mr. Smith today suggests that Judge Hippler acted outside of his discretion, acted contrary to legal principles, or lacked an exercise of reason in deciding that Mr. Smith is a vexatious litigant. Thus, it cannot be said that Judge Hippler abused his discretion. I'd like to briefly address the merits of Mr. Smith's procedural due process claim. Mr. Smith argues that he was deprived of some sort of constitutional right or interest without due process of law, but that is simply not true. Mr. Smith was provided with the opportunity to respond to the personal representative's motion to declare him a vexatious litigant. He was provided with an opportunity to respond to Judge Hippler's pre-filing order, and he has been given the opportunity to be heard in this forum today. In other words, Mr. Smith has been provided due process of law. In sum, Judge Hippler's decision does not constitute an abuse of discretion. and Mr. Smith's due process claims fail on multiple fronts. If there are no questions, we respectfully ask that this court affirm the district court's decision below. Thank you.
Thank you very much. Madam Clerk, it's my understanding Mr. Smith used all his 30 minutes in opening. Is that correct? Very well. Counsel, Mr. Smith, this matter is now under advisement. We'll render a decision in due course and be in recess until approximately 10 a.m.